not only did he not say that he had any belief in it, but the question is, from the material, are there any reasonable grounds for believing that that result which was put in the entry and the entry then announced was reasonably grounded? My lords, we say no. Even the facts before him, he himself knew, my lords, that over 10,034 A's were not available to him even at 14th August, and certainly not on the 10th of August when he was announcing the result. And any returning officer, much less a presidential returning officer, who is announcing a result without the 10,034 A's cannot reasonably believe in the truth of his entry. Secondly, my lords, if these primary documents, as has been said by the respondents, primary, and as Mr. Kerry thought, were the right place to check, if these are missing, my lords, can there be a genuine 34C? Because 34A's go into 34B, create 34B, and 34B's create 34C. How then was that entry made? If 34A's were missing, 34B's could not have been created, and 34C's. And if 34B's had been created with missing 34A's, then one of two things: the 34A's were present originally and then have gone missing, which creates a more serious doubt, and which a court cannot then disregard and confirm an announcement, so that the head of our state would sit in his office on the foundations of an announcement which was built upon the primary documents to the extent of 10,000 being missing, or being unlawfully held, or being unlawfully treated, so that when the scrutiny comes, that circle closes correctly. But after there has been some doctoring, my lords, the electronic images of 34 A's were not sent when the 34 B's were sent. And all we got, my lords, was extensive explanation of the electoral law being changed and what happened in the IBC and what their discussions were. No, my lords, that does not explain anything. What is important, my lords, is that the 34B, they have admitted that 34A's images did not always reach the tallying office. My lords, there are a whole number of steps that were wrong or missing or not completed, but I emphasize these important ones and say what is then happening in relation to this. There cannot be then any reasonable grounds. If he himself has not said there are reasonable grounds, the court may look at his own grounds. The court may look at other aspects and see maybe there were reasonable grounds for him to do what he did. We submit quite the contrary. Not only are there no reasonable grounds for a true belief in that result, in fact, it raises suspicions which should never come from that institution itself. My lords, in relation to this then, I turn to some smaller aspects. The court had asked the issue of the dying declaration issue from the video there. My Lord, it's of course not, as the court pointed out, not a dying declaration. But, my lords, if it is possible, may I draw the attention of the court to Section 33 of the Evidence Act, Cap 80. Statements by deceased persons made in the course of business. Here, so it says, when the statement was made by such person in the ordinary course of business, and in particular when it consists of an entry or memorandum or statements made by him in books or records kept in the ordinary course of business, or in the discharge of professional duty, or of acknowledgement written or signed by him for money, goods, etc., this same is admissible by Section 33. Here, it was made in his official capacity as an official of the IBC in the course of his normal business. Thank you. So that, my lords, it is admissible by virtue of the Evidence Act itself. Sorry. My lords, the submissions from the respondents were then aimed at saying, look, we've counted the votes, 2 and 2 make 4, and the gap is 500,000. Mr. Otiende Amolo has dealt with that, my lords. It is a concentration. Apart, your lordships will see when you weigh the submissions from the respondents, that it is concentrating on first procedural anomalies. Their affidavit is not this way, their affidavit is defective, the numbers are so small we added them up, the election was held with a secret ballot, etc., etc. My lords, there are more fundamental things that are wrong with the conduct of the first and second respondent, and the benefit of that wrongdoing which is accrued to the third respondent. And they are putting forward numbers. The gap is so large. The test is, and my learned senior pointed out that they had taken all sorts of criteria, and the right criteria was that there should be wrongdoing and the numbers should be affected. My lord, numbers are not the only test. Not only is the statutory provision subject to the Constitution is very clear. There are other tests in this Constitution, and they are the tests in Article 86. My lords, it's known to you by heart, but whatever voting method is used, the system is simple, accurate, verifiable, secure. My lord, it should not be so secure that they keep the 34 A's for 5 days. Accountable and transparent. It was none of that, my lord. Then, my lords, it was submitted in this respect that the numbers alone should be the test, because this is all about numbers. It is again in Article 81. There is another test. The whole of that article, my lords, that the electoral system shall comply with the following principles: free and fair elections which are administered in an impartial, neutral, efficient, accurate and accountable manner. My lord, these are not the Constitution is not putting simply highfalutin principles. The Constitution is going down to 34A and down to the voting paper. Are you doing it accurately? And are you doing it in an accountable fashion? And are you doing it in an efficient fashion? Holding 34 A's for these number of days is neither efficient nor lawful, etc. Then, my Lord, 38 itself, the voting, 138 itself, which was the third respondent's thing, also requires the same principles, that they shall tally and verify and then declare the result. And so, my lords, the tests which your lordships will apply to what is going on here, all placed before you. Where is the smoking gun? My lords, no person who is trying to manipulate or interfere with a process that gives rise to the highest power in the country is there for waiting to give us the smoking gun and photographs of it and a video possibly. No, my lord, there is a bigger test. And the test is, who will benefit by all this wrongdoing? And has the second respondent, the first respondent, and the third respondent placed before you any material which can shift, not the burden of proof, my lords, shift the unavoidable conclusion that something wrong has gone seriously with this entire process? No, my lord, that is a more important test. And that is what has happened in this. My lords, I turn then, without in any way admitting the submissions of the respondents, to the question, my lord, to the submissions of my learned senior, Mr. Ahmed Nasir. My lords, it was my learned senior's submission, my lords, that you could only upset the result by if you found fault with the voter. 99%, he said, of these cases are with the fault of the voter. My lords, that is not correct. It's not correct factually. Firstly, my lords, it is not only, it's not any submission of ours that is at variance with this submission. The Constitution itself is in variance with this. Article 81, my lord, talks about, and this is very important, it says the electoral system, not the voting, not the counting, not the tallying, the electoral system shall comply with the following principles. So that, my lord, 81 does that. 86, so it's not only the voter, the whole system must be proper. 86, at every election, the Independent Electoral and Boundaries Commission shall ensure whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. And see this duty, my lord, because it deals with the Form 34As as well. And the Commission shall ensure that D, paragraph D, appropriate structures and mechanisms to eliminate electoral malpractices are put in place including the safekeeping of the election materials. That whole correspondence, my lord, is in breach of this article, this duty upon them, and they frivolously talk about that they came, and it is our fault, my lord. It's our fault because when the matter came before the registrar, the second respondent, the first respondent, my learned senior, Mr. Paul Muite, said, we offered to give them all these forms. And they said no. My lords, they offered to give us these forms after the opportunity for malpractices was sufficient. They had already had time, and the matter came for directions much later, many days later after the result. So that righteously to offer us this, and said we were obsessed with these things, rightly so. And they said the numbers will be all right. With what confidence were they saying that the numbers will be all right? They didn't have that confidence on the 10th of August, nor when we wrote on the 11th, nor when we wrote on the 14th. But their confidence returns now. So that, my lords, we are not blind. We can also see when a man goes into hospital, my lord, carried into the trolley, he says, my leg, my leg. And it may well be that in the end, the leg is all right. But the doctors find that in fact the ribs were broken, perforating parts of his internal organs. Then you don't go to that man and say, you came into this hospital claiming for a broken leg, and you're a charlatan, and you're on a fishing expedition, because you went into the hospital saying one thing and let the doctor search out what it was. My lords, these are not serious responses that come in. Secondly, my lords, I go to the issue of my learned friend Mr. Ahmed Nasser, and that was a very important innovation in law that he made. He was supporting the issue of RILA 2013 and the reliance by your lordships on the Nigerian cases. And he says, what's wrong with that? Nigeria is a superpower. It's many times our GDP. My lord, this is a very important legal principle. I think that your lordships can take judicial notice that China's GDP is over 100 times ours, and the US is over 99 times, and I think you all should now go and get some Chinese cases and some more US cases, and then decide this. My lord, my learned senior will conclude the funeral procession and oration.
Mr. Nowrojee, Mr. Nowrojee.
Oh, I'm sorry, my lord.
Before you sit,
yes, my lord.
Do you have any Chinese authorities for us?
I'm so sorry. Thank you, my lord.
Thank you, my lord, and that's part of the high drama in this case, and it is from that that I want to begin the conclusion of the address on behalf of the two petitioners. My lords, we have not been short of drama in this case. It is learned counsel Ahmed Nasser who, raising the petition and pointing to your lordship that in this petition there is no cause of action, that it is nothing but fiction. In fact, it says it's science fiction. My lord, Mr. Hamid Nasir and his colleagues have taken this court through 6 hours of a response to a science fiction. And my Lord, if it was not a science fiction, I do not think that my learned friend Mr. Hamid Nasir would have taken that amount of time together with his colleagues. And if you look at the course of action, my Lord, in terms of the petition and the pleadings, all the respondents have made responses to our pleadings and filed affidavits which ran into volumes. And again, I'm saying this, that if there was no case in the petition, these responses would not have been there. In fact, they should have taken the shortcut by making an application for striking out the petition. And having said that, my Lord, there was also another very high drama in these proceedings, in which my little friend, Mr. Pielo Lumumba, whom I respect very much. In fact, my Lord, if it was terms of antiquity, I would have compared him to Cicero, who was a great lawyer and a great statesman. But my only problem, and I find it very difficult to respond to his submissions, is that the language of my little friend, with respect, most of the time is a melange. If you wish to say so in French, is a mixture of legal text together with common prose. So I would never know whether he is responding, you know, in terms of the language of in which the law is written, or whether he wants me to also to respond similarly in the kind of prose which is definitely poetic and for which I respect him. But my Lord, we have a definite question here. It is not about midwifery. It is about an election. Was there a free and fair election conducted by the first and second respondent? It's not about a baby. This is not a biological function or process. It's a legal process, and the product of which is a candidate who is declared a president. And by wanting to make that determination, you must go through not only the language of the text of the relevant legislation and the Constitution, but prove that indeed you have rendered an election in terms of the law. And which I want to point out from the case of Maina Kiai, which is a very important case in these proceedings and has been referred to many times. And I want to look at the penultimate paragraph of the case of Maina Kiai, which was Civil Appeal number 105 of 2017. And I think these conclusions are very important in trying to determine what type of responsibility we have in the conduct of these proceedings. And this is what the court said. The appellant, and that is the respondent in these proceedings, must in all its dealings be truly above suspicion and command the respect of the people of Kenya, for whom it acts. This is what the judges are saying, that they must be above suspicion and command the respect of the people of Kenya. There's a question of legitimacy also in this process. So at the end of the day, as Kenyans go back to their beds in the evening, they go back fully confident that they have a fair deal. And they go further and say, much depends on it. Indeed, the present and future peace of the country. This is what the court is saying. It is not just about that particular electoral process which was under consideration, but it's the people who must have a good future and peace. And therefore, coming back to this, some of the findings in the Maina case, Maina Kiai, my Lord, they put a lot of weight on the question of the mode of transmission and determine why that mode was important. It's not like Mr. Nyamodi says here that the question of transmission is like a matatu. You can decide to take a matatu, take a bus, but the law prescribes which is the mode of transmission, which must be electronic. And the court gave a reason why this must be so. And they say this, having gone through the history, the context of what this country has gone through. And they say this in the judgment, and I quote, which I read in part, and warn myself that I may be selectively reading this judgment as I must in the little time that I have. But they say this: the results announced at each polling station shall be transmitted to the constituency returning officer. Must be transmitted. And in another part of that judgment, they say that it must be an electronic transmission. And they give the reasons why this must be so. From our reading of all the provisions under review, the authorities relied on, and bearing in mind the history that we have set in detail in the judgment, we are convinced that the amendments to the Act were intended to cure the mischief identified by the then former chief chairperson of the appellant and other stakeholders. And this ranged from change of results between one level of election polling station to the county, to the constituency, rather the constituency, the county, to the national tallying center. So it was necessary right at the primary level of election, which are the polling station, that a transmission, an electronic transmission must be made of the prescribed forms so that there could be verifiability of the final tally of the results. And my lord, my ladies, they say in another part, which will be the final part of this judgment, which I shall refer to, that pursuant to Section 45, Section 5, aforesaid of the technology regulations, were promulgated to provide for, among other things, information security, data availability. And this is why this scrutiny that we ask for is very important: data availability, accuracy, integrity, confidentiality, and retention of the voting materials for 3 years following the elections. So, my lord, what am I saying? My lord, what I'm saying is that the issue of transmission by electronic means or conveyance is an important function in which this court must be satisfied that what was transmitted is what is provided for under the law. And the law says it is not the text. In fact, the question of text is not provided for under the law. The law requires that it is the forms, the prescribed forms are the ones which must be scanned and must be transmitted for purposes of verification and for purposes of accuracy and credibility. My lord, I must end up by again saying this to your lordships and my ladies, that elections have winners and losers. Even in court, depending on the nature of the proceedings, there are winners or losers. But at the end of the day, the process is so important, so as much as the result. So that even in judicial proceedings, people are interested in the process. And for that matter, therefore, my lord, I invite your lordships and my ladies that the question of the process and how the electoral process as laid out in the law and in the regulations was carried out is an important responsibility and function of this court. And I want to finalize by saying that if a proper scrutiny is carried out as the court has ordered, if everything available that the court has added to be availed to this court is brought before the court, your lordships and my ladies will find out that this election was a shambolic election. And with that, I thank you, my lords and my ladies.
Ahmed.